next unit we will be covering is the HIPAA privacy rule. And the objectives of this particular unit is to understand what the core requirements are for the privacy rule, what the key terms are, and the concepts are as it relates to the HIPAA privacy rule. Next slide. The topic that we will be discussing next is privacy rule introduction. Next slide. Now, the HIPAA privacy rule was considered one of the most sweeping healthcare privacy laws ever enacted. Up to this point, there really were no nationwide privacy laws on the books. A number of states had their own privacy laws that related primarily to specially protected health information. In other words, special categories of information such as mental health, genetic information, HIV/AIDS, and so forth, which were considered especially sensitive. There were stigmas associated with them and so forth. But up until the point that the HIPAA laws were passed, there was no national foundational healthcare privacy and security regulations or requirements. So this amounted to a very significant move in the direction of mandating further protections of privacy and security. And one of the reasons that this mandate occurred was that the healthcare industry was interested in assistance from Congress to adopt the national standards for administrative transactions for health information. And Congress made the decision that if they were going to assist the healthcare industry in simplifying the administration, in other words, lowering the costs of exchanging data for healthcare administrative purposes, there would be a requirement that, given this was electronic data, that there would be a mandate related to privacy and security. And that is one of the key reasons why the privacy and security language was added to the administrative simplification provisions of HIPAA, and then that, in essence, became the privacy and security rules. Now, the objective of the rule is to provide privacy protection without hindering the quality of patient care, and also to increase efficiencies. In other words, there were privacy protections included, patient rights included, and so forth. But as an example, one of the primary examples that can be looked at is minimum necessary. Now, minimum necessary requires that only the minimum amount of information necessary for that particular activity, whether it's internal to the organization or sharing information with somebody else, is exchanged. Now, treatment was an exception to that, and the primary reason it's an exception is that there was a concern on the part of providers that appropriate or quality healthcare would not occur if they had to second guess what kind of information they could send back and forth between each other to assist in providing that quality of care. And it also did not limit the amount of information that could be exchanged that were part of what was covered as a HIPAA-covered transaction. So in other words, a minimum data set is the transaction itself. So it said that if it is required for a claim, these are the fields, this is the type of information that's required. The minimum necessary is what is defined in the implementation guides for those particular transactions. So that, in essence, helped with the efficiency side while not compromising the privacy of the individual. Now, all HIPAA-covered entities are required to perform a thorough review of their privacy practices, clearly analyze the gaps, and take steps to bring the entity into compliance. That's an ongoing process, and this was effective April of 2003. So all covered entities should have gone through this particular activity and are on an ongoing basis maintaining their programs. And soon this will, well, actually now as a contract issue, it is required of business associates, and soon certain parts of the privacy rules, such as use and disclosure requirements, will be mandated by statute for business associates also. Next slide. Now, business associates are those entities that have a contract with a covered entity and they use and disclose on behalf of the covered entity protected health information. And use, again, is what happens inside the organization. Disclosure happens to be when it's extended or exchanged outside of the organization. So in essence, the exchange of data back and forth between the covered entity and the business associate, and business associates primarily fall into that category of organizations that have access to that covered entity's protected health information to assist them with a given task, such as billing, claims management, and so forth. Now, effective February 18th, unlike it is today where business associates must comply with the privacy rule by contract, but as of February 18th of 2010, business associates must comply with the use and disclosure provisions of the privacy rule by statute, which means that not only do they have to reasonably ensure. Next slide. Now, what are some of the requirements of the privacy rule? It included individual control of health information, and that's not to be confused with ownership. Under many state laws, the owner is the provider. So there is a legal ownership of that data. But what the privacy rule did do, is it allowed individuals certain control over their health information, such as access to that information, requesting amendments, and so forth. And this is to a far greater extent than before the privacy rule was enforceable on April 14th of 2003. Boundaries were established regarding use, which is internal, and disclosure, which is external, of business health information by covered entities and business associates. So in essence, it said this is what you can use this information for without the individual's consent or authorization, and here's where you need to go to that individual for that authorization. So now you have two layers. You have HIPAA, which has certain requirements where an authorization is required, generally when it goes beyond treatment, payment, healthcare operations, and then there are certain exceptions to that where it's allowable to exchange without authorization. And then you have the state law and some federal laws overlaying that do require authorization even for treatment, payment, and healthcare operations. So in essence, that was setting up the boundaries of how can I use this, how far can that information go, how much information can I exchange, and so forth. Next slide. Next slide. Now the rule required the development, implementation, maintenance, and enforcement of policies, procedures, and appropriate safeguards to protect the patient and the health plan member's privacy. So this gets back to a number of the issues that have been discussed in other sections or units, which is one of the more critical parts of demonstrating compliance with the HIPAA privacy rule is documentation. And then documentation includes the written policies and procedures, which need to be current, accurate, enforceable, and complete, and communicated to the appropriate workforce members. And also the appropriate safeguards that are there to protect patient and health plan member privacy, such as security safeguards around paper documents, requirements around how you're going to safeguard conversation between two employees that say there's a conversation about a patient, be safeguards such as that's required to be done in a closed room where the protected health information cannot be overheard by other individuals. Also, covered entities are held accountable through the process of informal processes to work with covered entities to address violations and also civil and criminal penalties. The accountable agency, or the agency that will hold covered entities and now also business associates, or soon to be business associates, is the Office for Civil Rights. Now, originally when the privacy rule was effective, the Office for Civil Rights had been designated as the organization that was responsible for education, enforcement, and management of the privacy rule. Now also the Office for Civil Rights is responsible for security enforcement, auditing, and so forth. This is one of the things to pay attention to, is that the HIPAA enforcement rule is designed to, wherever feasible, use an informal approach to rectifying any violations through, say, corrective action plans and so forth. But now there is more attention that will be paid to those violations, a greater chance for civil penalties, as well as potentially monetary settlements, as has occurred recently. And that is because of the focus that was put on it through the American Recovery and Reinvestment Act, the new provisions which included increased fines and also increased the or required that audits do occur excuse me, on a regular basis for both privacy and security. Now, if it turns out that through that informal process that a covered entity is required to take action to mitigate damages, to correct violations and so forth, as well as on the business associate side, that information will be included in a report that will be sent to Congress on an annual basis, and that information will be posted on the public website of the U.S. Department of Health and Human Services. And that is not dependent on whether or not a civil penalty or a monetary settlement is reached. It is dependent on whether there is a violation or not. It does not matter whether the final resolution is informal or it's a formal through the civil complaint, or excuse me, civil penalty process. Next slide. Next slide. Now, effective February 18th of 2010, business associates will be subject to the same enforcement mechanisms, which means that they will also be subject to audit. They will be subject to informal enforcement of violations. They will be subject to investigations. They will also be subject to the criminal penalties if someone, say, from a business associate chooses to steal information for their own personal gain. Some very stiff civil penalties, or excuse me, criminal penalties associated with that. Now, the U.S. Department of Health and Human Services is currently targeting the second quarter of 2010 to roll out a new privacy rule audit program. So it's a good idea to pay attention to what is happening, the events that are occurring as these new privacy and security requirements are rolled out. And it's a good idea to pay attention to what will be audited, when audits will occur, and so forth. Currently, the only audits that are occurring are security audits previously conducted by the Center for Medicare and Medicaid Services, now currently under the umbrella of the Office for Civil Rights. And again, civil penalties were significantly increased with the passage of ARA, Title 13, Subpart D, otherwise known as the HITECH Act. And those civil penalties now go all the way up. They used to be $100 per penalty, up to a maximum of $25,000 a year for the same type of violation. Now those penalties can go all the way up to $50,000 per violation, to a maximum of $1.5 million per year for the same type of violation. So again, the increase was very significant. Next slide. Next slide. Now, what information is covered? The privacy rule protects information that identifies an individual. In other words, it's a name, it could be demographic information like their address, it could be an email address, a website, driver's license number, and so forth. Because generally that's some of the information that is kept in that medical record or that claims record to identify the individual. It's something that identifies the individual's past, present, or future physical or mental health condition, diagnosis, and so forth. So any information about that individual, if it relates to an acute care, behavioral health, and so forth, all of that information, whether it's a diagnostic procedure, whether it's a treatment, surgery, what have you, all of that information relates to the health care of that individual or the condition that that individual has, such as diabetes or asthma. All of that is considered protected. Also, the privacy rule covers data that is maintained, used, or disclosed by a business associate or a covered entity on behalf of the covered entity for treatment, payment, healthcare operations, and other legally allowed purposes, or as specifically authorized by the individual. So in other words, the privacy rule lays out the three main categories: treatment, payment, healthcare operations. And unless there are state laws overlaying that, because it's a specially protected condition, information can be exchanged for those purposes without the authorization or consent of the individual. There are also other exceptions that are listed, such as public health and so forth, in the privacy rule, where information can be exchanged about the individual without their permission. But again, this was specifically defined in the rule. It's also important to remember that privacy protections do not end at the time of death. After a person dies, their health information continues to be protected. Yes, information can be sent to the coroner, the medical examiner, the funeral home, and so forth, but beyond that, that information generally can only be shared with somebody who is a legal representative and recognized by that state in which the person resided or was deceased in. It recognizes as a legal representative or someone who has the authority to represent that deceased individual, which would include someone, say, with a power of attorney, healthcare power of attorney. They may be a custodian or guardian, such as with a developmentally disabled adult, where the state is the custodian or guardian. In those particular cases, health information can be shared without the permission. Well, with a deceased individual, you can't get the permission, but without violating the HIPAA privacy rule. Next slide. Next slide. Now, what information is covered? Health records and all other individually identifiable health information used or disclosed by a covered entity or business associate on behalf of that covered entity in any form is covered by the privacy rule. This would include electronic information, paper, oral, faxed information, memories or thoughts. In other words, if I'm on the job and I'm taking care of a patient, it's an unusual case, and I would like to discuss that with, say, my significant other, a friend, and so forth, I am prohibited from doing that in such a way that the individual I am speaking with, who is not authorized to access that information, can determine who the individual is that I am talking about. So it goes well beyond just an electronic or a piece of paper that may be the paper chart. So it's keeping in mind that protected health information is defined very broadly. Next slide. Next slide. Now, what are individuals' rights? Now, one of the rights that an individual has is to reasonably ensure that the person understands what their privacy rights are. And those privacy rights are communicated through the Notice of Privacy Practices. The Notice of Privacy Practices should include information about the privacy practices of the covered entity. It should include the areas where protected health information can be exchanged without the individual's permission, and when permission is required or authorization is required, and also include what the individual's rights are, as well as who they can complain to. That needs to include a complaint to the individual organization, and also the right to complain to, in this particular case, the Office for Civil Rights, because this is the privacy rule. Also, in covered entities and business associates need to reasonably ensure individuals are allowed access to their medical or claims records, with very few exceptions. And generally what this means is that a covered entity will create what's called a designated record set. And a designated record set defines all of the information that will be included in either a medical record or a claims record that will be released to that individual. It will include such information as the claim information if it's a health plan, maybe the treatment or lab results if it's a primary care physician, but it will include all of that information that will be included. Now, the individual has the right to request a copy of that record, which the covered entity can charge a reasonable amount to make those copies and also to send the information to the individual, but they must tell them in advance what that cost will be. Also, the individual has the right to request to review that record. Now, if they request to review the record, then the covered entity cannot charge the individual to view their record, even though the cost to pull that record together may be the same as if they provided a copy to that individual. But again, the covered entity cannot charge an individual if they request to view their record. It also protects the rights of an individual to complain about privacy rule violations and potential violations to their own personal privacy. They can complain to the covered entity or the business associate, and they can also complain to the U.S. Department of Health and Human Services, in this case the Office for Civil Rights. The covered entity or business associate cannot retaliate against the individual for filing a complaint with the Office for Civil Rights. Next slide. Next slide. What the privacy rule does is it provides recourse if privacy protections are violated, such as filing a complaint with the Office for Civil Rights. It does not include, though, what is called a private right of action if the covered entity violates the privacy rule, or when the business associate is statutorily required to adhere to the use and disclosure provisions of the privacy rule, the private right of action against the business associate. That means that the covered entity or the business associate cannot be sued primarily because they violated the HIPAA privacy rule. It does mean, though, that an individual can take legal action against the covered entity or the business associate if there was a violation of privacy protections and it resulted in damages to the individual. And those could be emotional damages, loss of job, monetary damages, and so forth. Legal risk is very high as it relates to privacy